a very warm welcome to Bharata First. You're watching Big Picture with me, Frank Rausen Pereira. Since you're here, please like the video, subscribe, hit the bell icon, and do share the content as well so that more people get to know about Bharata First. Do subscribe to our newsletter to get some incisive content. The Bharata First team runs several quizzes. Do participate in them. If you like our content, please contribute to keep it alive. Let me also take this opportunity to inform you about Bharata First Knowledge Center, an initiative that will help each one of you in your competitive exams and transform the way you learn. Go to kc.bharatafirst.com for more details and register now. Experience a whole new way of gaining knowledge. Hundreds are already reaping the benefits of the Knowledge Center. Don't be left behind. Register right now. There's so much more that we have to offer. All this information along with some must-see recommendations are in the description of the video. Please go through it. And now on to the discussion. The Supreme Court of India on Monday expressed its displeasure over the way the Union government enacted the Tribunals Reforms Act, calling it a virtual replica of the provisions struck down by the court. The bench, comprising Justices NV Ramana and DY Chandrachud and L. Nagendra Rao, also slammed the center over the delay in filling up vacancies in the tribunals. The apex court posted the matter to next Monday and said that it expected appointments to be done by then. Meanwhile, Justice Chandrachud said that the functioning of tribunals like NCLT and NCLAT was affected because of the lack of adequate members. Stating that the court was extremely upset with the situation, the Chief Justice of India, NV Ramana, said that we have only three options. One, we stay the legislation. Two, we close down the tribunals and give the powers to the High Court. And three, we ourselves make the appointments. Now, in this edition of Big Picture, we will analyze the Supreme Court's ultimatum to the center over vacancies in tribunals. Joining me on the program today are P.K. Malhotra, former Law Secretary, Government of India; Nitin Chandran, advocate to the Supreme Court of India; and Devayan Roy, special correspondent of Bar and Bench. Thank you to all my guests for joining me on this edition of Big Picture. Mr. Malhotra, let me start the program with you first. How would you look at this entire issue of vacancies in tribunals and what the Supreme Court has observed and where this issue is really headed?
Frank and Beck, the vacancy position in the tribunals is not a new issue. It has been going on like in the judiciary for subordinate courts as well as for the high court judges. These vacancies in the tribunals have been there for a very long time. The reason is, first is the process itself is too lengthy, and then there is no centralized recruitment process for these tribunals. All these tribunals are controlled by individual ministries, different ministries, and each ministry starts its own process. No doubt, they are governed by the various enactments passed by the parliament, under which there are committees constituted, and most of these committees, when appointments are to be made headed by a judge of the Supreme Court, who is nominated by the Chief Justice of India. But many times, in spite of the fact that there is a procedural delay in making a recommendation by this committee on a reference received from the ministry, many a time the government also takes unduly long time in making these appointments, because of which the situation is, I think, has gone beyond control, and the Supreme Court has to make this kind of observation where it says that probably either you are not following the directions given by the Supreme Court from time to time, or we have come to a stage where almost you are allowing the tribunals to close down. As for the latest figure available with me, in spite of the fact that the number of tribunals in the country has been reduced from 35 or 36 to only 15 as on today, even in the important tribunals which actually help the courts to reduce the pendency in the courts for quick redressal of grievances of these specialized areas, in most of these tribunals, the vacancies are too. Take, for example, the National Company Law Tribunal, which is considered to be most important. As on today, there are reported to be 19 vacancies of judicial member and 14 of the technical members. Similarly, Armed Forces Tribunal, which deals with the service matter of the armed forces, there are 13 vacancies of judicial member and 10 of the administrative members. In the National Green Tribunal, you have 14 vacancies of judicial member and 16 of the administrative member. And Income Tax Appellate Tribunal, which is considered to be the mother tribunal of all the tribunals because it is in existence since pre-independence period and is responsible for dealing with all direct taxes appeals. The number of vacancies there is 25 of the judicial member and 27 of the accountant member. And the post of the president of the tribunal itself has fallen yesterday. Government has not made any appointment. Only the vice president has been asked to officiate as president of this tribunal. So I think this is a sorry state of affairs in a way, even in respect of cases where the recommendations have been made by the committee headed by the Supreme Court judge way back in May 20 or June 20 or November 20, the government has not yet cleared it. The message is very clear. I think if you don't want to clear the recommendation made by such a high power committee where the government officers are also involved, secretaries to the government of India who work as a member of the committee where they are also involved, if the government doesn't want to accept it, the government should take a call on it. They should decide it, either accept or reject it. Even if you are rejecting, at least the fresh process will start. And because you keep it pending for so long, therefore the Supreme Court has given this kind of observation, and these observations are not coming for the first time. They have come in the past also, but ultimately, I mean, still the fact remains that there have been delay on the part of the executive in filling up these vacancies. I think if you really want the tribunal to succeed in the functions which have been given to it, then obviously these processes need to be expedited. And to that extent, the observations made by the Supreme Court are valid and deserve a due attention on the part of the executive.
Absolutely. Deven, let me come across to you now. Let's first try and understand and analyze this aspect as well. You know, how serious is the executive really to go ahead and get these vacancies filled up? What is the sense that you're getting?
See, first we have to understand that bottom line of the entire controversy is rooted in the Tribunal Reforms Act and the previous legislations which were made to that effect, and also the legislation which has been just passed by the Parliament on the 13th of August 2021. Now, the issue is there has been a series of Madras Bar Association cases in the Supreme Court in which, starting from the tenure point, salary and allowances point, etc., the Supreme Court time and again has given a set of guidelines to which the government has enacted a law which is completely contrary to what the Supreme Court laid down. And again, Madras Bar Association appealed in the Supreme Court or challenged the act. And then again, there was a judgment. So now, the Tribunal Reforms Act 2021 has again proven to be a bottleneck. So one of the most possible reasons why there's been a delay in the appointments to the tribunals is there is a confusion in the bureaucracy as well as among the members of the fraternity who are going ahead with this appointment, is that how do we make these appointments? The appointments which have been made to these particular tribunals have been made keeping in mind the earlier legislative scenario which was prevalent. However, now the situation has again changed after the Tribunal Reforms Act. For example, take the example with tenure of the members. Now it's again back to 4 years when the Supreme Court has already said that it should be 5 years. So like these, there were several bottlenecks which were erased by the Supreme Court in its last judgment, headed by Justice Nagendra. And now again, those bottlenecks are back to square one. So one of the first pertinent questions which the Chief Justice of India sought to know from the Solicitor General was that the bench has only 3 options before them. One is to issue a contempt notice because their judgment was not being followed. Secondly, they go ahead and make the appointments and remove executive out of their way completely. And thirdly, the government puts a stand across before the bench that whether at all they are serious about the tribunals or not. If they want to close it down, they can reassign the cases back to the high courts as the situation was before the tribunals came into being. So this is, the background of the entire controversy, the legislative bottleneck, and the scenario that unfolded in the courtroom. So now the Solicitor General has, I think this time, taken the 4th adjournment in the case and said that we are going to make appointments. Now, there has been a lot of clamor in the press about the fact that the Supreme Court has come down heavily upon the central government and they have to make the appointments by next Monday when the case is taken up. But unfortunately, there is nothing like that. In the order sheet, if you peruse the order sheet, there is no such direction from the Supreme Court. that by Monday or the next Monday, these particular vacancies have to be filled. When the CGST matter came before the Supreme Court, again, an oral observation was made by Chief Justice of India NV Ramana that we hope to see these vacancies be filled by next Monday. This terminology "hope" is a very vague term. If you are reporting on court, law, and justice, this never translates into an order of the court. There is a high possibility that the next Monday also, the central government comes before the court and says that there have been certain bottlenecks with the judicial officers, with the executive members, and we need some more time to fill the vacancies. So now when the only option which, according to me, which the government has is to ask, the court has is to ask the government, which the Chief Justice of India had taken down a list of names or the vacancies and had read out in the open court. So now the next hearing could be a threat of contempt action against the central government. And you know what, that often works. That's a sword which keeps hanging on the executive as well as we, the common people, and that often works at the end of the day. And that is why probably he did not include it in the order, but as a passing reference, he referred to it. Also, one very important fact that should not be missed here is the tribunal vacancies have been at a staggering high for the last 3 years. As for my personal interactions with the lawyers at the National Company Law Tribunal, the RERA Tribunal, Real Estate Tribunals, etc., they are virtually dead. Even for regular matters, which are generally heard in a day and orders are passed, they are getting adjourned for about 3 to 4 months. So the condition is pathetic. And I think the concern of the court was rightly placed on this fact that if the government is not serious about the tribunal's functioning, then these cases can be reassigned back to the court. The pendency of the case, the pendency of the courts will rise, taking that into account. However, the common people will have some recourse to justice, but as of now, I don't think any of the cause lists which are heard in these tribunals are at all being heard on a day-to-day basis, and no daily orders are being passed. So that is the factual backdrop for you.
Absolutely. All right, Nitin, coming to you now, let's understand really some of the challenges as far as the tribunals are concerned when these vacancies are not filled up. What is the kind of problems that arise? What are the kind of challenges that one gets to see on a daily basis?
So the Supreme Court has rightly said you are making the tribunals weaker or ineffective by not filling up the vacancies. And the very simple example that we get to see on day-to-day basis in the tribunals are, for example, NCLT, Insolvency and Bankruptcy Code, Section 9, Subclause 5, specifically states that all matters should be adjudicated within 14 days from the date of notice. So if there are no judges, if the vacancies are not properly filled up, no members, how is it even possible to adjudicate that matter within 14 days? Because they are already overburdened with work. So how do you expect the justice to be delivered within a time-bound manner? Now, what was the purpose of setting up tribunals? To provide faster, less expensive, and more informal process for deciding specialized disputes. But when you paralyze these tribunals by not filling up vacancies, it is not at all possible to adjudicate matters within a time-bound manner. Now, what was the purpose of Insolvency and Bankruptcy Code? Time value of money. Now, if you are unable to do that, you are affecting the entire economy. The executive, the legislatures have to realize that in this pandemic times, if they want to boost the economy, it is very important that we have an efficient tribunal or commission or judicial system. Because when they are able to deliver the justice in a time-bound manner, it boosts the entire economy of the country. They have to realize that if they are not appointing the members, the judges within a time-bound manner in these tribunals, they are only going to affect the economic system of the country, which on the other hand, they are saying they are going to boost the economy by doing efficient policy, by efficient policies and all those things. But you have to first look into the system which helps in adjudicating the disputes. So I believe the legislatures, the executives have to realize the importance that judicial system has a very strong role to play in the economic growth of a country. And if they paralyze that, it is only going to affect the overall economic system of the country and the judicial process of the country.
Absolutely. Mr. Malhotra, coming back to you now, let's talk about the observation of the Honorable Supreme Court and what the Solicitor General also said. They both said that they do not want to see any kind of confrontation, and they do not want any kind of confrontation. And that's something that has been reported clearly by the press as well. But the way things are headed and the way things are going right now, it looks like they are headed for a confrontation.
Frank, so far as confrontation issue is concerned, I think confrontation is not mandatory. But the fact remains, if you look at the constitutional scheme, we, the people of India, who have framed the constitution, have created three organs of the government under the constitution: the executive, legislature, and the judiciary. And each organ has been assigned certain jobs. Now, if the executive is not performing its duty, is it not the responsibility of the judiciary under the law or under the constitution to give a direction to the executive? And if that direction is given and not complied with, this kind of situation arises, and therefore the concern expressed by the Supreme Court appears to be genuine, that why there is delay. And as Nitin has rightly pointed out, all these specialized tribunals are dealing with a specialized subject, and they don't follow the normal procedure of CPC or the Evidence Act. They decide disputes based on the principles of natural justice. And the idea was that there will be quick disposal of cases. But if you are not filling up the vacancies, if you are not providing them proper infrastructure, if you are not getting experts member on the bench, how you are going to dispose of all these cases? And that is why the pendency in the tribunals is increasing, and the very objective of getting these disputes addressed or settled expeditiously gets defeated. The other important point, I think, which Roy also mentioned, was this Tribunal Reforms Act of 2021, which the Supreme Court has adversely commented. You see, there was an ordinance. Certain provision of the ordinance was struck down by the Supreme Court, and thereafter the same ordinance was converted into an act without bothering. The certain provision of the ordinance has been struck down by the court. So this will give a cause to the fresh litigation. Roy also mentioned about the various Madras Bar Association cases. But so far as the tribunalization of justice in this country is concerned, I think it has achieved its purpose. And the Supreme Court has upheld this kind of support, because they are deciding the cases on the pattern as the courts are deciding. The process started way back in 1987, when the Supreme Court upheld the constitutional validity in the case of SP Sampath Kumar case of the Administrative Tribunal Act. And thereafter, the 9 judges bench in L. Chandra Kumar case also said that the tribunalization of justice is here to stay. I still remember the observations of Justice Ravindran, who delivered judgment in the first Madras Bar Association case in 2010, when he laid down that what are the basic principles on which the tribunals should be constituted. If you're compromising with those basic principles, then you are compromising with the justice administration system itself, and probably that needs to be avoided. And unfortunately, that is not happening. The kind of amendments which have been made, either in the Finance Act of 2017, when certain amendments were made through the Finance Act, which was totally uncalled for, and which was again challenged before the Supreme Court, and the later suggestions which have been given by the courts. Yes, if the suggestions given by the courts are not acceptable to the executive knows the ways how it can be handled. But unfortunately, it is not moving on that direction, and probably the executive want to show an upper hand insofar as running of the tribunal is concerned, and that is somehow going to affect the justice administration system through tribunals. And that is why this strong observation came from the Supreme Court. Does the government want to close down the tribunal? Of course, I think the Solicitor General has rightly said there is no intention. If that is not the intention, the other alternative is the executive should take due steps in filling up these vacancies as expeditiously as possible, provide proper infrastructure, put all these tribunals under the administrative control of one ministry, so that there is uniform service conditions available for all the members, and the process of making recruitment can be expedited.
Absolutely. Debayan, coming to you now, talking about expedition of, matters. it doesn't look like we are headed in that direction. Filling up of vacancies is one aspect, completely agreed. But what about the infrastructure? That too needs to be looked at, isn't it?
See, if you remember the 2019 study, if I'm not wrong, which was conducted by India Spend, they had come to a conclusion that about 1% of India's or 0.08% of India's GDP in the budget is allocated for the Indian judiciary. When we are talking about all of this vacancies in tribunals, it's not only limited to the members of the chairperson. It also goes up to the the people like peons, clerks, staff. There was a connected case before Justice Nagendra Rao's court, in which the court had correctly observed that when we are talking about vacancies in tribunals, just by appointing members and chairpersons, you can't really have orders, because you can't have the chairperson and members searching or digging through the case files, getting those dusty files in the court, and going through those the bundles of material if you don't have a support staff mechanism. So the entire structure of the tribunals that exists in the country is currently crippling down. Secondly, Justice Chandrachud had very correctly, when I'm just going a little off track from your question to what Mr. Malhotra was just saying about the Tribunal Reforms Act. So Justice Chandrachud had observed that a parliament has all the power to take away the basis of a legislation, right? But this particular act which has been formed or which has been passed, the Tribunal Reforms Act, is not a validating legislation. So here comes a very important and crucial observation from the court, which was not sadly reported enough, because this particularly throws light on a possible aspect of a court in the future striking down the Tribunal Reforms Act 2021. And don't be surprised if this act is again challenged. It is already being challenged by Jairam Ramesh, but I'm sure there'll be a slew of petitions in the Supreme Court challenging the same. So, judicial infrastructure, when we talk about the judicial budget, it all stems not from the government's willingness only, but also about the past. When we talk about the government's budget, we talk about 2017, 2018, 2016, 2019. But if you see from 1970s, if you do a detailed analysis of the budgets which has been presented in the parliament, you will see that the judicial infrastructure, the judiciary, has only been allocated about 1 or 2% of the GDP of the nation, and it has been always so. When the CJI comments that women do not have toilets in courtrooms, when the judges comment that there are no proper sanitation facilities in the district courts, then we can very well assume what is the condition in the tribunals across the country. So, this actually paints a very sad picture. And this actually shows that if the government really wants to improve the judicial infrastructure, if the government really wants to go ahead with the, with filling the vacancies, it needs to start in the month of February when the budget, or the month of March when the budget is presented. That is the first step. So unless and until that improves, the salary and allowances part, which has been amended in the Tribunal Reforms Act 2021, and it is being hotly debated, it also finds certain roots in this entire budgetary issue that we spoke about. So, this is a brief answer to your question, but again, this can take hours of discussion when we get into year-wise analysis of how it's not happening.
Absolutely. Nitin, coming back to you now, so what does all of this mean for pendency of cases? Because that's another issue, and that's something that we can talk about for hours together as well. But let's touch upon this aspect too, pendency of cases, and what all of this means for that.
So to give you a very simple example, when there are vacancies are not filled up, when the judges are overburdened, and there is a specific act which says that you have to adjudicate the matter within a specified period. So when they give the next date of hearing, it is probably after 6 months or 7 months, or probably even after almost a year. The very date that you are giving frustrates the entire purpose of the act and the entire purpose of formation of the tribunal. So when we talk about appointment of the members, the judges in tribunals, commissions, other authorities, it should not just be restricted to those members and judges. It should also be with respect to that support staff, because until and unless there is no support staff, it cannot function effectively, efficiently. As stated, to issue the dusty notice or to even issue the notice to the parties, there should be a support staff. And this is what is happening in reality. So for example, if we talk about the new Consumer Protection Act 2019, the pecuniary jurisdiction have been increased for district courts up to 1 crore for state commission, from 1 crore to 10 crore, and for National Consumer Dispute Redressal Commission above 10 crores. Now, if you go to District Consumer Forum, they do not have the staff. One member is presiding the entire 4 benches of the District Commission. So that completely frustrates the purpose. You have enacted an act, you've brought into a law as an act, but you are not able to make it function effectively, which frustrates the entire purpose, which also takes away the belief, the trust of the people on the judicial system of the country. This should not happen, because with an efficient and an effective judicial system, it boosts the morale, the economy of the entire country. So we have to always give utmost priority, be it in the budget, be it in whatever manner it is possible. We have to give utmost priority and importance to the judicial system. And
Sure.
it is only possible if we simplify it, if we do not complicate it, if we don't create bottlenecks in the appointment of the members, the judges, the support staff, so that we can simplify the entire process, so that every year, whenever the judges or the members retire, there is already an appointment which is ready, that yes, they can take over the vacancies which has come up, and simplify the entire process.
Absolutely. All right, gentlemen, time to get quick closing comments now from all my panelists with the best way forward, starting first with you, Mr. Malhotra.
Frank, the way the Supreme Court has made observations and has threatened the executive with the contempt proceedings also, I think the opportunity should be availed by the executive to see whether there is a need. This opportunity should be used to review the whole process of tribunalization of justice in the country. I think the way we have done the constitution of tribunals in an ad hoc manner, for each tribunal you pass a separate legislation, put different service conditions, and give them different kind of power, needs to be reviewed. This ad hoc approach of tribunalization is not desirable. There is a need to have uniform service condition for the members of the tribunal. There should be security of tenure available to these members, and there should be same kind of independence in the functioning of these tribunals as is available to the court. I personally feel that there is a need to have a single act to deal with all these tribunals, which should be administered by one ministry, so that there is a uniformity and there is a clarity among the executive as well as among the judiciary as to in what way we have to go and how this can be done. I think example can be taken from Australia, where you have one Administrative Tribunals Act, where all the tribunals are governed by this act, and there is a separate administrative tribunal services available, like judges are recruited. Therefore, the administrative tribunal members are also recruited, and they man different kind of tribunal. If we approach that tribunal, probably the kind of problems which we are facing today, we can avoid all those problems.
Absolutely. Devayan?
Yeah, so a couple of things. Firstly, when we talk about vacancies in tribunals, we also address that there are proper benches of these tribunals functioning. A very sorry state of affairs when a CGST tribunal in Madhya Pradesh has to depend on the CGST tribunal in Lucknow. Right, so the Lucknow bench is now acting as a pseudo bench for the Madhya Pradesh bench to hear cases. The NCLT bench of Jaipur is being heard by the bench of Chandrachud, which already has 4 areas under its control, including one union territory. So there is this immense need to also have proper segregation of benches, and that is also one of the cases before the Supreme Court which is being heard, and that was a germinating case which led to all of these comments from the Supreme Court bench. Secondly, when we talk about the Supreme Court coming down heavily on the executive, all of this will transform into the paper only when this is actually translating into an order of the top court. When it becomes an order of the top court, it actually holds the power of the Damocles sword, and it actually can force the executive to not toe the judicial line which has been set through this number of judgments which has been delivered by the Supreme Court. Thirdly, I may sound very pessimistic, but I am not very hopeful that this entire thing will see a very an end very soon, because a government or the institution which has passed so many acts to overturn Supreme Court judgments on the same issue, there's very less likelihood that this is going to end up very soon. There's only going to be litigation after litigation in this entire thing. One thing that has to be ensured in this entire process is that the independence of judiciary is not compromised. One of those rare pillars in our democracy has to be respected, and we can only hope that that happens in this case. And lastly, why do we have tribunals? As Mr. Chandran was correctly saying that it is a measure, or it is a platform to have speedy redressal or access to justice. But the system of appeals, the system of appeals in our Indian judicial system has the effect of crippling down the entire mechanism. Whether it's NCLT or a debt recovery tribunal, you are bound to appeal this in the High Court, then in the Supreme Court. So there needs to be an end to all of these litigations. So the entire purpose of having this tribunal gets defeated. You are just having another forum to litigate, and whoever has a little bit of financial, a backing or a financial scene of mind, they can approach the higher court. So the system of appeal also probably should see some closure, but the vacancies in the tribunals is very less likely to end very soon with the Tribunal Reforms Act now in the picture.
Absolutely. And Nitin, close the show for us with your quick concluding remarks.
The government has to realize the ramification of not filling up the vacancies of the tribunals on the overall economic as well as judicial scenario of the country. If they realize that it is only going to delay the justice, and it is only going to take away the belief and the trust that people have over the judicial system of the country. So they have to simplify the entire process by ensuring the independence of the judiciary and fast track the appointment, so that well in advance they have appointments ready for a vacancy which is going to be created the moment one of the members retire, so that the efficient working of the tribunal system is not affected. And that is only possible if we simplify the entire process of appointment without compromising the independence of the judicial system, and ensuring that the proper support staff is also there to support the judicial members as well as the or other members of the tribunal.
Absolutely. All right, gentlemen, we'll have to leave to that. Thank you so much for joining me on the program and putting things into perspective for us. Well, what's coming out of this discussion is that there are massive vacancies in the tribunals that need to be addressed at the earliest. The issue is not just limited to vacancies. Judicial infrastructure as a whole needs immediate attention. Yes, emergency surgery is required right now in tribunals, as pointed out by the Honorable Supreme Court, but it's a year-long process and quick fixes are not enough. For starters, the budgetary allocation for the entire judicial system needs to be increased. The structure of tribunals is disintegrating. It needs urgent care. The large number of vacancies in tribunals defeats the whole purpose of having them in the first place, as it increases the pendency of cases. What we need is a uniform service condition and a single act that governs all tribunals under one ministry, so that accountability is fixed. Well, before I go, once again, let me remind you to like the video, subscribe, hit the bell icon, and then share the video as well. Do subscribe to our newsletter to get some incisive content. The Bharata First team runs several quizzes. Do participate in them. If you like our content, please contribute to keep it alive. Let me also take this opportunity to inform you about Bharata First Knowledge Center, an initiative that will help each one of you in your competitive exams and transform the way you learn. Go to kc.bharatafirst.com for more details and register now. Experience a whole new way of gaining knowledge. Hundreds are already reaping the benefits of the Knowledge Center. Don't be left behind. Register right now. There's so much more that we have to offer. All this information, along with some must-see recommendations, are in the description of the video. Please go through it. Well, that's it from me. See you again next time.